I'm going to read the Indian Contract Act. This book is very self-explanatory, so please take a listen. Section 2A of the Indian Contract Act 1872 defines an offer as when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of the other to such act or abstinence, he is said to make a proposal. Now, A offers rupees 5 to B if he would mow his lawn. The promise to pay rupees 5 is binding as soon as B promises to mow the lawn. Until then, A is free to withdraw his offer. Essentials of a valid offer. The essentials of a valid offer are as follows. An offer must be one to give rise to legal consequences. To constitute an offer, offerer must intend to create a legal obligation. Where such intention is lacking, the agreement is not a contract. Further, where an agreement clearly provides that it shall not be subject to legal jurisdiction, then there is no contract between the parties. Social invitations are examples of offers made without the intention of creating legal obligations. For example, if A invites B to dinner and then forgets all about it and goes out of town on the stipulated date, B cannot claim compensation for expense and inconvenience as there was no intention to create a legal obligation. In Balfour versus Balfour, 1919, the husband promised to pay £30 to his wife every month. On his failure to pay, the wife sued him for the recovery of the amount, held that she could not recover as the agreement did not create any legal relationship. Warrington, Lord Justice, observed, there is no contract here. These people never intended to make a bargain which could be enforced in law. The husband expressed his intention to make this payment and he promised to make it and was bound in honor to continue it so long as he was in a position to do so. The wife, on the other hand, made no bargain at all. Offers made in jest and excitement cannot be construed as offers as they lack contractual intention and are made without any thought or intention of creating a binding obligation. In Weeks versus Tybalt, 1604, the defendant in the course of a casual conversation said that he would give £100 to anyone marrying his daughter with his consent. He was sued for the amount. It was held that such general words spoken to excite suitors could not be taken as seriously intended. In Nutaki Sheshta Ratnan versus Sub-Collector Land Acquisition Vijayawada AIR 1992 Supreme Court Decision 131, it was observed that the statement of the appellant amounts in law to no more than an offer. Till the offer is accepted, there is no contract between the parties and the appellant is entitled to withdraw his offer as the appellant is in no way bound to keep the offer open indefinitely. The terms of the offer must be definite or capable of being made definite. An offer must be certain and definite and not uncertain, vague or loose. If the offer is uncertain, an essential element is lacking and it cannot be accepted. In Taylor versus Pottington, 1855, A promised B to take a lease of a house for 3 years at £85 per annum. If the house was to put into thorough repair and the drawing rooms decorated according to present style, held that the terms were too uncertain and that the promise could not be enforced. An offer must be distinguished from an invitation to offer. An offer is to be distinguished from an invitation to offer exemplified by advertisements, marked price of goods displayed in shop windows or catalogues mentioning prices of goods. In all such cases, the trader or advertiser is simply inviting an offer, that is indicating that he is willing to consider an offer to pay the goods on the terms set out in the advertisement or catalogue. He is not making an offer. In Harvey versus Facey, 1893, X telegraphed to A, "Will you sell bumper hall pen? Telegraph lowest cash price. Answer paid." A replied by telegram, "Lowest price bumper hall pen, $900. X telegraphed, "We agree to buy $900 asked by you." In a suit by X against A, it was held that the mere statement of the lowest price at which the vendor would sell his estate bumper hall pen contained no implied It did not imply to sell. It did not imply offer to sell at that price, and that the reply was no reply to the question whether agreed to sell the property. It was therefore held that there was no concluded contract between the parties. In Macpherson versus Appanna in 1951, P wrote offering to B D's property for rupees 6,000, to which D replied, "Won't accept less than rupees 10,000." P informed his acceptance of the price of rupees 10,000, but D sold it for a higher price to another. Had that the mere statement of the lowest price by D contained no implied offer to sell at that price? Held that the mere statement of the lowest price by D contained no implied offer to sell at that price. That it was no counter offer which could result in a concluded contract by its acceptance by P. Every offer must be communicated to the offeree. Every offer must be made known to the offeree. Otherwise, he will not be in a position to accept, inasmuch as he will have no knowledge of the offer. The mere desire to enter into an agreement will not constitute an offer. As observed by Lord Linley, a state of mind not communicated cannot be regarded in dealings between man and man. A written communication setting out a definite proposition will have no effect till it is duly posted and reaches the offeree. The essence of a contract being mutual assent, communication becomes vitally important, for there cannot be mutual assent if the offer is not communicated to the offeree. So, what are the essentials of a contract? 1. An offer must be one to give rise to legal consequences. 2. The terms of the offer must be definite or capable of being made definite. 3. An offer must be distinguished from an invitation to offer. And 4. Every offer must be communicated to the offeree. General and specific offers. An offer need not always be made to an ascertained person, but it is necessary that an ascertained person should accept it. For example, if a person offers a reward to anyone who finds his lost diamond ring, the finder can successfully claim the reward. The position will, however, be different if the finder has no knowledge of the reward. For example, in Lalman Shukul versus Gauri Dutt, it was held that the servant was not entitled to claim the reward because it came to his knowledge after he had discovered the boy, which he was obliged to do as a servant. When an offer is made to the whole world, acceptance of the offer and performance of the condition will be sufficient for making it an enforceable contract. A well-known illustrative English case on the point is Carlyle versus Carbolic Smoke Ball Company. In this case, the defendants were proprietors and vendors of Carbolic Smoke Ball. They advertised a reward of £100 to any person who contracted influenza after using the smoke ball for a certain period according to the printed directions. In order to show their sincerity, they also deposited $1,000 in a bank for the same purpose. The plaintiff, a lady, used the smoke ball according to the printed directions, yet she contracted influenza. She brought an action to claim the reward. It was held that she was entitled to claim the reward. The court pointed out that in an advertisement cases, an offer may be made to the whole world, but it becomes a promise only when it is accepted by an ascertained person. Acceptance. In India, Section 8 of the Contract Act provides performance of the conditions of a proposal or acceptance of any consideration for a reciprocal promise which may be offered with the proposal is an acceptance of the proposal. Thus, there may be a general offer or an offer can be made to the whole world, but it becomes a contract only when a specific person comes forward and accepts it or performs the conditions of the offer. Void agreement. According to Section 2G of the Indian Contract Act, an agreement is not enforceable by law is said to be void. The appellation void is in relation to a juristic act, means without legal force, effect or consequence, not binding, invalid, null, worthless, cipher, unless an ineffectual. Nutan Kumar versus 2nd Additional District Judge, Banda, AIR 1994, ALL 298. All the agreements which are declared by the contract to be void are detailed below. Contract by a minor or a person of unsound mind. Section 11 of the Contract Act provides, every person is competent to contract who is of the age of majority to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. 2. Contract made under a mistake of fact material to the agreement on the part of both the parties. That is section 20. An agreement of which the consideration or object is unlawful. Section 23. If any part of a single consideration for one or more objects, or any one or any part of any one of several consideration for a single object is unlawful, the agreement is void. Section 24. An agreement made without consideration is subject to 3 exceptions. Section 25, that is, an agreement in restraint of marriage, void. Section 26. An agreement in restraint of trade, section 27. An agreement in restraint of legal proceedings, section 8. Agreements, the meaning of which is not certain or capable of being made certain, section 29. Agreement by way of wager, section 30. An agreement to enter into an agreement in the future. An agreement to do an act impossible in itself, section 56, clause 1. An agreement not enforceable by law, as in the above, shall be accordingly void ab initio. An agreement offending a statute or public policy or forbidden by law is not merely void, but it is invalid from nativity. It cannot become valid even if the parties there to agree to it. Nutan Kumar versus 2nd Additional District Judge Banda, AIA 1994. Section 23 of the Indian Contract Act mentions what considerations and objects of an agreement are lawful and what are not. While the term object, unlike the term consideration, has not been defined in Section 2 of the Act, it has been held to mean as purpose or design of the contract. If the object is opposed to public policy or tends to defeat any provisions of law, it becomes unlawful and thereby it is void under Section 23 of the Act, Nutan Kumar versus 2nd Additional District Judge, AIR 1994, Allahabad 298. An agreement is void if considerations and objects are unlawful in part. In Union Carbide Corporation versus Union of India, AIR 1992, Supreme Court Decision 248, it was observed that non-compoundable offences which are a matter of public concern cannot be subject matter of private bargains, and administration of criminal justice should not be allowed to pass from the hands of the judges to private individuals. Alright, where the offences of a public concern, no agreement can be valid that is founded on the consideration of stifling of the prosecution for it. Okay, the payment of $470 million by the Union Carbide Corporation to Union of India was held not to be stifling of prosecution, and the payment was not unlawful. Means it was lawful. The distinction between illegal and void contracts is very thin, but is there. The law may either forbid an agreement to be made, or it may merely say that if it is made by the courts, will not enforce it. In the former case, it is illegal. In the latter, only void. Nutan Kumar versus 2nd Additional District Judge Banda, AIR 1994, Allahabad 298. Acceptance to offer what a lighted match is to a train of gunpowder. It produces something which cannot be recalled or undone. But the powder may have lain till it has become damp, or the person or the man who has lain the train may remove it before the match is applied. Explain with illustrations the principles sought to be expressed in the above passage. Section 2A of the Indian Contract Act defines proposal as when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Section 2B defines acceptance as when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. Section 7 of the Contract Act provides that in order to convert a proposal into a promise, the acceptance must be absolute and unqualified. be expressed in some usual and reasonable manner unless the proposal prescribes the manner in which it is to be accepted. If the proposal prescribes the manner in which it is to be accepted and the acceptance is not made in such manner, the proposers may within a reasonable time after the acceptance is communicated to him insist that his proposal shall be accepted in the prescribed manner and not otherwise. But if he fails to do so, he accepts the acceptance. Section 8 further provides that performance of the conditions of a proposal or the acceptance of any consideration for a reciprocal promise which may be offered with the proposal is an acceptance of the proposal. In the words of Sir William Anson, an acceptance is to a proposal which is a lighted match is to a train of gunpowder. It produces something which cannot be recalled or undone. But the powder may have lain till it became damp, or the man who laid the train may remove it before the match is applied. So, an offer may lapse for want of acceptance or be revoked before acceptance. Acceptance converts the offer into a promise and then it is too late to remove. Thus, an offer once accepted explodes into a contract. The offeree, when he signifies acceptance, is called the acceptor. A valid acceptance comprises the following essential features. Acceptance must be communicated in some usual or reasonable manner. Acceptance should be made before the offer is revoked or rejected. Acceptance should be absolute and unqualified and correspond with the terms of the offer. And acceptance is thus an expression of an agreement to the terms of the offer by the offeree. It may be made in usual or reasonable manner unless the offer itself prescribes the manner in which the acceptance is to be indicated. If the offer says, please wire reply, and a reply is sent by post, there is no compliance with the offer unless the offerer accepts it as such. Again, where an acceptance is to be indicated within a specified date, late acceptance will have no effect. No particular form of words or mode of expression is required for an acceptance. An acceptance may be signified in the case of a unilateral contract by performance of the act called for. Where an acceptance had been communicated to the offerer but not in the manner prescribed, the proposer may, after a reasonable time, insist that the proposal be accepted in the prescribed manner and not otherwise. If the proposer fails to do so, he is deemed to accept the acceptance. Acceptance must be made only by the person to whom the offer is made, and if someone else tries to accept the offer, there is no contract with such person. In Bolton versus Jones, 1857, A sold his business to his manager without disclosing the fact to his customers. On the afternoon of the day on which the sale was carried through, a customer, Jones, who had a running account, sent an order for some goods and addressed to the vendor of the business by name. The new owner of the business executed the order without disclosing that the business had changed hands. It was held that he could not recover the price as there was no subsisting contract. An acceptance should be absolute and unqualified and correspond to the term of the offer and must be expressed by means of an external act indicating the mental assent. While communication of acceptance need not conform to any particular term or type, unless prescribed for in the offer, silence can never be construed as acceptance. Please be mindful, silence is not acceptance, okay? In Oriental Insurance Company Limited versus Gowarana, the appellants, AIR 1994, the appellants did not clear the doubt whether Siddhappa had insurable interest in the vehicle proposed to be insured before accepting the policy, and the appellants were prevented from taking stand which is contrary to proposal and acceptance I'll read it again. In Oriental Insurance Company Limited versus Gorana, the appellants did not clear the doubt whether Siddhappa had insurable interest in the vehicle proposed to be insured before accepting the policy, and the appellants were prevented from taking stand, which is contrary to proposal and acceptance once the policy has been accepted. The provision of Contract Act were against the insurer. An acceptance with a variation is no acceptance. It is simply a counter proposal which must be accepted by the original promise before a contract is made. Haji Muhammad Haji Jiwa versus E. Spinner 1900. Oh my god, it's old. Still we are reading it. Revocation of proposals. Section 5 of the Indian Contract Act says, a proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer, but not afterwards. An acceptance may be revoked at any time before the communication of the acceptance is complete as against the acceptor, but not afterwards. Illustrations. A proposes by a letter sent by post to sell his house to B. B accepts the proposal by a letter sent by post. A may revoke his proposal at any time before or at any moment when B posts his letter of acceptance, but not afterwards. B may revoke his acceptance at any time before or at the moment when the letter communicating it reaches A, but not afterwards. When an offer gives the offerer an option to accept within a fixed period, it may be withdrawn even before the expiry of that period unless there is some consideration for keeping it open. Air Shantang versus Muthurayana Chetty, 1892. Oh my god, it's way old. Further, Section 6 provides revocation how made. A proposal is revoked by the communication of notice of revocation by the proposer to the other party, by the lapse of the time prescribed in such proposal for its acceptance, or if no time is so prescribed, by the lapse of a reasonable time without communication of the acceptance, by the failure of the acceptor to fulfill a condition precedent to acceptance, or by the death or insanity of the proposer, if the fact of his death or insanity comes to be the knowledge of the acceptor before acceptance. Decide whether following are offers: catalogues and display of goods, announcement to hold auction, free distribution of articles, tender. Catalogues and display of goods. A shopkeeper's catalogue of prices is not an offer. It is only an invitation to be intending customers to offer to buy at the indicated prices. The transmission of a price list, observed Lord Herschel, does not amount to an offer to supply an unlimited quantity of the wine described at the price named, so that as soon as an order is given, there is a binding contract to supply that quantity. If it were so, the merchant might find himself involved in any number of contractual obligations to supply wine of a particular description, which he would be quite unable to carry out, his stock of wine of that description being necessarily limited. Granger and Sons versus Gao, 1896. For the same reason, the display of goods in a shop with price chits attached is not an offer, even if there is a self-service system in the shop. This was so held in Pharmaceutical Society of Great Britain versus Boots Cash Chemists Limited, 1952. Lord Goddard, Chief Justice, said, "It would be wrong to say that the shopkeeper is making an offer to sell every article in the shop to any person who might come in, and that person can insist on buying an article by saying, 'I accept your offer.' In most bookshops, customers are invited to go in and pick up books and look at them even if they do not actually buy them. There is no contract by the shopkeeper to sell until the customer has given the book to the shopkeeper or his assistant and said, 'I want to buy this book,' and the shopkeeper says yes. That would not prevent the shopkeeper seeing the book picked up, saying, "I am sorry, I cannot let you have that book. It is the only copy I have got and I have already promised it to another customer. Therefore, I am of opinion the mere fact that a customer picks up a bottle of medicine from the shelves, in this case, does not amount to an acceptance of an offer to sell. It is an offer by the customer to buy, and there is no sale effected until the buyer's offer to buy is accepted by the acceptance of the price." A banker's catalogue of charges is also not an offer. State-aided Bank of Travancore versus Dhitram, AIR 1942. A railway timetable is in the same category. There is no direct authority for this, but this seems to be the most likely conclusion. Railway timetables include clauses against such contingencies. However, in one English case, namely Denton versus Great Northern Railway, the railway company was held liable in damages for fraud for cancelling a train. Where a shopkeeper was convicted of offering for sale a flick knife contrary to the restriction of offensive weapons. Contrary to the restriction of Offensive Weapons Act 1959, I'll read it again, where a shopkeeper was convicted of offering for sale a flick knife contrary to the restriction of Offensive Weapons Act 1959, which he had displayed in his shop window, it was held that it was in no sense an offer for sale, the acceptance of which could constitute a contract. Fisher versus Bell. Announcement to hold auction. An auctioneer's announcement that specific goods will be sold by auction on a certain day is not an offer to hold the auction, and he will not be liable to persons travelling up to the place if he changes his mind and does not hold the auction. Harris versus Nickerson. See also Union of India versus Gangadharan Mohandas, in 1997 to Calcutta. Cancellation of auction after due consideration. No bidder can claim anything under the doctrine of legitimate expectations. Even when an auction is held, the bid is not an acceptance so as to entitle the highest bidder to get the goods. The highest bidding is nothing more than an offer to buy, and it requires to be accepted by the auctioneer. Spencer's versus Holding, 1870. It does not matter for this purpose that the auction was held by the government. Even a government auction may be cancelled before any bid is finally accepted. After cancelling the auction, in this case the right to fell trees in a forest, the right was handed over to a government corporation, and it was considered to be no argument that a corporation cannot afford to pay an amount equal to private bidders. The Supreme Court also gave this latitude to a government, as is enjoyed by a private auctioneer, that it may even ignore the highest bid and accept a lower bid. The highest bidder may be found to be an undesirable person for many reasons. Example, for the mere enormity of the bid. Jyoti Krishna Engineers versus State Bank of Hyderabad, AIR 1993. However, one contractor should not be preferred over another without any rhyme or reason. This would be more so in the highest bid is nothing more than an offer to buy, and it requires to be accepted by the auctioneer. Spencer versus Holding. It does not matter for this purpose that the auction was held by the government. Even a government auction may be cancelled before any bid is finally accepted. After cancelling the auction, in this case the right to fell trees in a forest, the right was handed over to a government corporation, and it was considered to be no argument that a corporation cannot afford to pay an amount equal to private bidders. The Supreme Court also gave this latitude to a government, as is enjoyed by a private auctioneer, that it may even ignore the highest bid and accept a lower bid. The highest bidder may be found to be an undesirable person for many reasons. Example, from the mere enormity of the bid. Jyoti Krishna Engineers versus State Bank of Hyderabad. However, one contractor should not be preferred over another without any rhyme or reason. This would be more so in the matter of government contracts, where out of the participating bidders or tenderers, any one is called to revise his figures. An equal opportunity should be given to the highest bidder or the lowest tenderer. Gajendra Singh versus Nagar Palika Nigam, AIR 1996, provided there is otherwise, nothing against him. So next is C. Free distribution of articles. I hope you guys are taking a listen to the contract. This is the Indian Contract Act. Well, to be honest, I love reading, but sometimes I might not understand certain things where you can come in and help me. I'm making these videos to reach out to people who love to learn through listening. There are many people who listen and learn through listening and listening only. So I want you guys to listen, and as much as possible I am going to read out acts and different kinds of books. Please let me know which book you want me to read. Till then, take care. I'll come back to read to have another session of this. Till then, take care. Bye bye.